The International Coalition for the Abolition of Surrogate Motherhood is organizing a series of meetings today in connection with the International Day for the Elimination of Violence Against Women. The subject of this webinar is surrogate motherhood as an accumulation of violence against women. And we are delighted to have Anna Zobnina as our guest speaker. Anna is the Strategy and Executive Director of the European Network of Migrant Women.
Thanks a lot to the coalition, SIAM's coalition, for this invitation and for organizing this event. So I was asked to speak about surrogacy, which is an important subject for our network for many reasons, and I want just to mention them briefly. Our network, European Network of Migrant Women, is a member organization in the Coalition for the Abolition of Surrogate Motherhood for several years now. And 2 years ago, we conducted a research jointly with this coalition that focused specifically on reproductive exploitation, surrogacy, but not only, because there are different overlapping forms of reproductive exploitation of one particular group, which is a group of our concern. It's migrant women, refugee women, displaced women, basically women who move across borders for various reasons. Sometimes it is voluntary movement, sometimes it is involuntary movement, and sometimes it amounts to actual clear-cut forms of trafficking. In this study that we conducted, it was actually the first of the kind that looked specifically at how surrogacy, the whole kind of industry and the market and abuse that happens within it, how it impacts or potentially can impact migrant women. We identified clear patterns. It was a desk research primarily, and we looked at different media sources and analyzed media clippings and from different countries with a focus on some specific countries, but basically it was a global study. Patterns that we identified were very, very clear. First of all, the very hypothesis that we have, whether migrant women are exploited, whether they're affected by exploitation and surrogacy, it was confirmed. Yes, they are. Secondly, how it happens, there are several, let's say, routes and methods of how women are moved from country to country. Sometimes it involves not just moving women to one country, but moving women to 2, sometimes 3 countries. This is done to circumvent legal frameworks, in those places where surrogacy is banned or prohibited, certain parts of surrogacy kind of process, then bringing women back to the country of origin to give birth. So there are various scenarios. All of them, all without any exception, are made to serve the buyers of children, and of course those who make profit from it, the third parties, and the third parties are quite numerous. So it is not just some guy who is a gangster, as we see in the movie. There is an involvement of very well organized medical clinics, doctors, also the legal practitioners, lawyers, those who are helping this industry to operate in the most profitable and non-criminalized way. And then, of course, there are those who advertise it online in different platforms, and the presence of those who are operating kind of technologically is also obvious. The reason that we wanted to look at it is because as a network, we work on violence against women since our foundation, since 2012. The violence against women as such is a cross-cutting priority for us. That means that we look at various aspects of migrant and refugee women's rights, from health to employment to education to access to services. And violence against women and discrimination is cross-cutting all of those areas. So it is not something new for us. And as a network as well, since our foundations, we had abolitionist position. That means that we are a network that supports the Nordic model on prostitution. And obviously, by extension, we do not recognize commodification of women as any form of employment. It was only natural for us as well to take a position that views surrogacy as a form of reproductive exploitation and as a form of discrimination and violence against women. We focus our work on women who are known to be one of the most marginalized and excluded and destituted groups in Europe, but also globally. And of course, it is not a surprise that when there is any industry, profit-making industry, where a profit will be derived from a female body, it is not a surprise to anyone who knows anything about inequality between women and men that the most marginalized women will be the most affected and the most exploited. And so again, not only the understanding, but the desire to look into the subject of kind of cross-cutting of surrogacy and various forms of reproductive exploitation and migration and migrant and refugee women was very natural to us, because we're very familiar that it is our target group, it is our members who will be impacted most by this kind of exploitation. Now, today is almost the day on elimination of violence against women. And when I was asked to present, I considered, okay, what shall I speak about? Shall I speak about the research that we did? It's already 2 years that we conducted this research. Shall I speak about the legislation that some European Union kind of moves that are happening at the level of the European Union or Council of Europe or the UN? Shall I speak about the impact of surrogacy on individual women? And then I thought, what I'd like to do, and I will try to be brief, I think it's a very huge subject, and it's a sort of an exercise for myself. It's a little bit of a draft thinking, is how we can really conceptualize surrogacy and reproductive use of women as a form of violence against women. And of course, this is in large part because tomorrow is the day on elimination of violence against women. So I wanted to link it specifically to this subject. And it might sound kind of obvious for anybody who either works on violence against women or on women's rights or on subjects of prostitution and of course on surrogacy, that it is a form of violence against women. But the thing is that if we look retrospectively at how international law was developed, violence against women as such is quite a new term, in the sphere of human rights. It is not something that, for example, when CEDAW was written, you do not find specifically violence against women as a term in any of the articles of the CEDAW Convention. And this is relatively recently. I mean, the CEDAW is 1979. So the new instruments that we have on violence against women, such as the Istanbul Convention, they're very recent. So it's 2010, 2011. It's this period for the last 10, 15 years when there is a kind of a stronger push from legislators. I don't mean the feminist community that, of course, has been working on the subject for a long time, but at the level of state decision makers and international decision makers, to really create some binding instruments that would oblige the states and would oblige the policymakers to actually recognize violence against women as a crime. I see that I am frozen on my screen. This is my screen. I do not know how it is for you. I'll just switch my video for a second and then switch it on again.
We can hear you, Anna. We can hear you very well. Thank you.
Okay, okay. And now I can see that I'm moving on the screen again. So yes, those who are working more in a legal sphere, you would know that violence against women as a term, as a concept, as a definition is relatively new. And for example, right now, there is a sort of a discussion at the UN level whether there is a possibility, maybe, I think it's not going to happen easily, to introduce a new protocol, a new optional protocol, kind of an addition to CEDAW, which does not have as such violence against women. It only has it in general recommendations. So to introduce a protocol on violence against women, which also says to us and that we still have a lot of work to do in this area, like from a legal perspective. And of course, when we think, we were thinking, okay, what is going to be included in this protocol? Yes, domestic violence, pretty much, everybody is sure that this will be included. Maybe femicide, it's not so much into national laws, but there is a possibility that we will include trafficking, yes. And then we come to more contested issues, the issue of prostitution rather than just trafficking. We do not know how states are going to think about it. And then there is issue of surrogacy. For us, it doesn't make sense to have an optional protocol on violence against women if actually it does not incorporate a very, very fast-growing form of exploitation of women, global exploitation of women, as we know from research, and that actually impacts only and specifically women. But is it going to make it to this protocol or not? It depends. It depends on political will. But what I wanted to kind of spend some time today is to think together with anybody who is in the meeting or watching it online is how we can better conceptualize surrogacy as an exploitative practice, as an act, as a form of violence against women. And there are, of course, different ways to look at the crime of surrogacy. One is very obvious, one is used quite often, is trafficking. And of course, without a doubt, there is a very clear, when it concerns children, for example, there is one person buying a child and transporting a child, even if it is just from a hospital bed into her or his house. This would constitute basically a sale of children and a form of trafficking. There is a whole perspective on the rights of the child that can be applied here. There is, of course, perspective of exploitation. And exploitation, the problem with this word as such, that it is actually not defined in international law. And just to give you an example, so we have the term sexual exploitation in the European treaties. It's one of the so-called Euro crimes. It's a serious crime of transnational nature. And there is no definition of what exactly is sexual exploitation. So one would assume that at a very minimum, it should be prostitution. But according to the new proposal that was finally rejected from the European Commission for the new directive on violence against women and domestic violence, rape would be qualified as a sexual exploitation, because this article in the treaties on sexual exploitation constituted the basis for this directive. And therefore, if rape would be included, as is FGM right now in the directive, it becomes kind of integrated in the definition of sexual exploitation. But this is just to say that there is no clear definition of sexual exploitation. And the fact that states take this very discretionary approach. They did not in the end include rape, but they did include female genital mutilation. They could very well include surrogacy. It didn't happen, but there is a possibility, and definitely reproductive exploitation stands very, very close to sexual exploitation. And then there is the last perspective is the perspective of women's rights. in which the violence against women is integrated. And this is, again, what I want to focus on. So what is it actually, violence against women? We have certain criteria and certain definitions. We know, according to both CEDAW and Declaration on the Elimination of Violence Against Women and the Istanbul Convention, that violence against women is gender-based violence. It's a bit circular definition, but let's say it's a type of violence which they call gender-based violence that is directed against a woman because she is a woman, and it affects women disproportionately. So this is one criteria that defines violence against women. And, from all forms of violence and exploitation, we have forms like female genital mutilation. Does it affect men? No. And another one, surrogacy. Does it affect men? No. So it's of course, it is directed against a woman because exclusively of her reproductive capacity. And then we have kind of other criteria for what makes the violence against women, the gender-based violence, as they say. So according to the Declaration on the Elimination of Violence Against Women, so this is 1993, violence against women should, it results or is likely to result in physical, sexual, mental harm or suffering to women, including threats of such including threats of such acts, as well as coercion or arbitrary deprivation of liberty, whether occurring in public or in private life. Now, I will not go into different forms of different impacts on of surrogacy, and I'm not the most qualified to speak on this subject, like from a medical perspective, for example. But there are plenty of experts, and some of them will speak today in other webinars, lectures after me, who can give an extensive list, the list of harms. And what is defined as a harm or a suffering, and in different kind of areas, whether it's physical, and we know that some instances, some cases of surrogacy, women actually died. They died while giving birth because there is a risk at a complicated birth and the risk of to mother's health when she's giving birth, and we have cases of women when they died. Sexual, it's not perhaps so much limited to sexual, but I would say sexual reproductive in this case. And without a doubt, there can be made a big list of harms that are done to women through surrogacy. And mental, we know about various consequences for women, including post-traumatic stress disorder. And this does not concern just the women exploited in commercial surrogacy, but also in the so-called voluntary surrogacy and the act of separating the baby from the mother, and various realization of being exploited, and the neglect also as one part during and after a woman gives birth. So what I'm heading towards is that if we make, so we have one part of the definition that is directed against a woman because she's a woman and it affects women disproportionately, then this kind of violence should result in physical, sexual, in our case, sexual and reproductive and mental harm. And we can make tables and list those specific harms. Another aspect of what defines violence against women is subordination of women to men. So if we look at all of those documents, like the Istanbul Convention, but also Declaration on the Elimination of Violence Against Women, it states very clearly that violence against women is not just on its own. It is a kind of a mechanism, a tool to keep women in the position of subordination to men. It's also connected to stereotypes, which is another important aspect. But in terms of this subordination, I think that the illustration of how surrogacy subordinates women, not only right now, because we know that from biblical stories, we know how women were used for what is today called surrogacy, when women were raped and made to carry a child, and then the child is taken away from them. So basically, women are used as reproductive assets. And of course, this is a position of subordination. Now, we can elaborate more on this, but this is also an important criterion. It's a systemic understanding of this form as a form of violence against women. And then something else. So, as I said, CEDAW does not have in its articles the mention of violence against women as such. What it has, however, is some reference to maternity. So CEDAW does speak, first of all, in its preamble, it speaks about the social significance of maternity, and we need to go back to those little words in those treaties. We don't have many of them. We only have one treaty on discrimination against women, and we need to pick those words and give them significance and kind of interpret them and argue. I mean, what does it mean, social significance of maternity? Then there is a mention of women's role in procreation, which should not be the basis for discrimination. Then there is Article 4, again, that speaks about protecting maternity, but this is about special temporary measures. And it speaks that special measures to protect maternity should not be considered as discriminatory, because such measures, they won't be applied to men. They will never be possible to be applied to men, because men do not get pregnant. And then Article 5 speaks also about it. Well, it's about education and family roles, and it speaks about the education should include the proper understanding of maternity as a social function. We might not like all of these wordings. I was recently having a discussion with somebody who was questioning the very wording role in procreation. These are the matter of semantics. I mean, this is what we have in the convention. We can't do much about it, but we can interpret it and we can place it in a contemporary context. However, going back, so there is this mention of maternity in CEDAW, in preamble, and in some articles, and there is no mention of violence against women as such. But we have general recommendations that the CEDAW committee produced, and we have 2 general recommendations on violence against women. And the last one, general recommendation 35, which builds on the general recommendation 19, which is also on violence against women. And this is where they speak about subordination as violence against women as a, well, I will quote it, that it is one of the fundamental social, political, and economic means by which the subordinate position of women with respect to men and their stereotyped roles are perpetuated. But also, General Recommendation 35 did something else. It recognized violence against women as, well, they call it gender-based violence against women, as a part of customary law. So meaning that actually it might not be legislated as such, but because it has been used numerously and for a long period of time in different constitutions and national laws and even international instruments by that point, it kind of becomes a de facto, de jure at that point law. What it says is that violence against women has to be understood as a part of sex-based discrimination. And this is because it is CEDAW. So everything in CEDAW has to be linked to CEDAW Article 1, which explains what is discrimination against women, and it is a discrimination on the basis of sex. So therefore, and then in consequent recommendations, it is repeated that violence against women or gender-based violence against women is actually a part of this umbrella of sex-based discrimination against women. And this is, again, I think it's important to make this connection because, and speaking about, women, targeting women because they're women, targeting women, the types of violence that affects women disproportionately. With regards to sex-based discrimination, what it also affects, of course, is the principle of equality between women and men. Because as long as women are discriminated on the basis of sex, and sex, according to CEDAW, is this distinction, it is what makes difference men and women, and on which basis we become discriminated. So the equality, which is the ultimate goal between women and men, will never be possible to achieve as long as it is perpetuated. So in this sense, of course, there is a wider lens of understanding surrogacy in our case, which is a form of violence against women, a form of sex-based discrimination by the definition of CEDAW, and an important mechanism to keep subordination of women. And on top of this, an obstacle, a fundamental obstacle to achieving equality between women and men. I just wanted to kind of, to give this, maybe it sounds a little bit simplistic, and I am sure that for many feminists, it makes perfect sense, like we know those things. But actually, if you look at different legal arguments, if you look at how CEDAW is generally not very much used, it is not brought up in defense of women. Violence against women was not in CEDAW, so now we're kind of retrospectively trying to catch up. So as I said, I think there is a lot of work to do on how to conceptualize, including and actually in legal terms and in court cases, of arguing that surrogacy as such, by ticking the boxes, does it constitute this, does it constitute that, it's like a sort of a test that we can make on whether it is a form of violence against women, whether it is a form of discrimination on the basis of sex, and it impedes equality between women and men. Additionally, of course, what we need to take into consideration is that once the practice of surrogacy becomes understood as a sex-based discrimination, sex-based discrimination is a very broad term according to CEDAW, and incorporates various aspects. So it is public, it is private, it is workplace, it is family, it is education, it is political rights, it is health, various aspects. I mean, it's supposed to be completely comprehensive, and there is other openings that we have, and there is opening into human dignity. So of course, human dignity is already, it's pretty obvious also according to the EU and the European law, and it is something that is not often looked when we speak about women, and that's because women were not understood as a subject who has human dignity, because the human dignity was afforded to men. But the principle of non-commodification of human body, which is a violation, which derives from the principle of protection of human dignity, is very important. And here we go back to kind of how we understand human dignity. As I said, we don't have it enough conceptualized, even in the legal vocabulary and writing, and we don't have enough precedents that actually, if you look like when human dignity of women is defended in courts, we don't have enough of those cases. We have some interesting cases, such as, for example, in France, the defense of abolitionist law on prostitution, which I think is a very important parallel, because it gives us this opportunity to look what it means. What does human dignity in application to, well, in this case, it will be to anyone, because anybody can be prostituted, even though women, of course, are prostituted most. But we can bring it back to what it means when a female human dignity is violated. And of course, CEDAW also recognizes it. CEDAW also speaks about an understanding of violence, discrimination against women as a violation of human dignity. So again, we can go back to kind of sex discrimination, human dignity, but not just human dignity in generic neutral terms, but human dignity of women, for example, in relation to protection of maternity function. As CEDAW puts it in the preamble, the role and significance of maternity. And then I'm going to conclude here because, you know, if we build upon this, then we have the violation of human dignity. There is, of course, violation of the right of integrity of the person. This is what we have in the Article 3 of the EU Charter of Fundamental Rights. Human dignity, it's transversal. It is primordial. It is what is called, they call it sometimes the mother of other rights. So, and we have precedents that some other rights are permitted to be restricted, such as the right to work, again, going back to the case of French law on prostitution. But there is not a single case where it would be permitted, where we can see that human dignity was restricted by some other right, a right of so-called imagined, which doesn't even exist, of somebody to have a child, because actually we know it's not a right in international law. There's a right to create a family, but not to have a child, let alone purchase a child. So violation of human dignity at the intersection of sex-based discrimination, violation of integrity, and this very clearly in the EU Charter states that women, that persons, no one's body should be commodified and used for commercial profit. So there is a prohibition on making the human body and its part as such a source of financial gain. Then there is, of course, right to health, which is both in CEDAW and in the European law. And as I said, there is equality between women and men. So I wanted to make this kind of general overview of connecting these different elements and bringing it to the subject of today and tomorrow, violence against women. And hopefully that we will have maybe some tool in the future where we can say, you know, like they have the test for, I do not know, for films, is it sexist or not sexist? And in this case, we can have such in application to surrogacy, but it needs to be developed by feminists and by feminist jurists, and such cases should go to court. That's it from me. Thank you very much.
Thank you very much, Anna. This was really very, very insightful for all of us, and your view on international human rights treaties is really precious to our discussions. Of course, human dignity is the very first ground for all the human rights, and your observation concerning surrogacy as a sex-based discrimination and violation is extremely important for us all. As far as I saw, there is one comment, I don't know if this is a question, who says, Gulser Kair, I don't know if I pronounce correctly, says, firstly, psychological ethical aspects aren't important, are not important. I'm not sure I understand what it means.
For me, it's also not very clear. I mean, they are actually important, both psychological and ethical. They're not, it's not the same. But in terms of the psychological impact, just as we have victims of rape, victims of any other forms of honor-based violence, forced marriage, trafficking, prostitution, looking at the psychological damage done by a certain act is extremely, extremely important. The problem is that it's not women's suffering, women's psychological suffering is not well recognized, it's not well studied, the fact that women may not even understand that their rights are being violated, or they, they're entitled to redress and compensation and reparations. It's another aspect, but yes, it is very important. Ethical, it's not, I mean, for me, this is not a one word, psychological, ethical. These are two different things. One is a more personal aspect of a human suffering and a damage and a harm done to a human. Ethical, this is something that, it's a moral, ethical framework. And there is, I think, this conversation, well, the argument that, we shouldn't be moralistic, maybe, we shouldn't be ethical. Yes, I think we should. We absolutely should. Both moralistic and ethical, because it's our obligation. This is what makes us different from animals. We created moral codes, and the entire legislation is derived from them. So yes, it's a little bit silly argument, I think, maybe, who never ever even understood the history of philosophy or law. So yes, that's, I don't know if I answered, because there was no question. I think it was like a statement.
Thank you very much again for this very, very rich and insightful contribution to our event today.
You're very welcome. Thank you.
Thank you.